What is community property in an uncontested divorce? Imagine dividing a shared life into fair parts without any arguments. That's what community property is all about. When couples decide to part ways smoothly, understanding community property helps make the process easier. In states that follow community property laws, everything earned or bought during the marriage is considered shared. This includes income from jobs, real estate, cars, bank accounts, and even debts like loans or credit card balances. The law presumes that both spouses own half of these assets and liabilities, no matter whose name is on the title or who earned the money. If you own property before marriage or received it as a gift or inheritance, that usually stays separate property. But if you mix separate property with community property, like depositing inheritance money into a joint bank account, it can become part of the shared assets. This process is called commingling, and it can complicate property division. During an uncontested divorce, both spouses agree on how to split their property. They create a property settlement agreement that clearly states who gets what. Since they agree, the court usually approves this plan without much fuss. This makes the divorce faster and less stressful. In these cases, the law starts with the assumption that all property acquired during the marriage is community property. If one spouse claims an asset is separate property, they need to prove it. Otherwise, the court will treat it as shared property. To sum it up, community property means that anything gained during the marriage is owned equally by both spouses. When they agree on dividing these assets, the process becomes straightforward. They list all assets and debts, decide who gets what, and put it into a legal document. This helps avoid disputes and speeds up the divorce. Knowing about community property ensures that both spouses get a fair share and that the divorce follows the law.